Yang Arif, may it pleases the court. My name is Siti Nohaja binti Muhammad Mani. I am appearing on behalf of the prosecution in against of Mr. Hakim, the accused in this case. Yang Arif, my plea in mitigation today will be focusing on the prosecution by addressing the relevant provision on the sentencing guidelines, and then I will deal with the aggravating factors that the court may consider in sentencing the accused. The aim of my plea in mitigation today, Yang Arif, is to persuade the court to impose the heaviest punishments against Mr. Hakim on his offence. And now, I propose to take 10 minutes of the court time to present my submission before the court. If there is no other preliminary questions from the bench, may I start my submission, Yang Arif? Much obliged. Yang Arif, I'm looking firstly at the facts of this case as well as the personal circumstances of Mr. Hakim. At time of the arrest on 5th April 2020, Mr. Hakim, the accused, was found near a fishing pond at kawasan Kolam Changlun, Kubang Pasu, Kedah. He was on a motorcycle type Honda EX5 with a plate number KAD 2668, carrying fishing rods. Mr. Hakim was then arrested and charged for an offence under Regulation 11 subsection 1 for offending Regulation 3 subsection 1 of Prevention and Control of Infectious Diseases, Measures within Infected Local Areas, number 2, Regulations 2020. On conviction, the accused shall be liable to a fine not exceeding 1,000 ringgit or to imprisonment for a term not exceeding 6 months or to both. Yang Arif, in pursuant of the epidemic that happened because of COVID-19, the Minister of Health of Malaysia has prescribed a Movement Control Order or MCO on its citizenry after being satisfied that all states and federal are in threat because of the life-threatening microbial infection that is on rise via human transmission. Accordingly, as specified in Part 1 of the first schedule of the Prevention and Control of Infectious Diseases Act 1988, Act 242, the state of Kedah has been declared to be an infected area and was prescribed a movement control order effectively from the period from 18 March 2020 and has been extended until 14 April 2020. Yang Arif, thus, it has to be noted that the accused has offended Regulation 3 subsection 1 of the said regulations by moving from one place to another place within an infected local area for a purpose which is not provided for in Regulation 3 subsection 2. As the aim of the regulations is to promote public good for the citizens in alleviating the looming epidemic of COVID-19 in Malaysia, it shall be the duty of the citizens to abide and adhere to the MCO by staying at home safely and to observe hygiene. Yang Arif, not only the prosecution wants to suggest the court to impose the heaviest punishment to the accused, it will also be appropriate for Yang Arif to be mindful of other alternative sentencing that is available in our penal system of justice, such as deterrent. Basically, the purpose of deterrence is to punish the accused so that they will repent and does not repeat the same offence. In R versus Sargent, the court even though does not oblige to reflect public opinion in their decision, but they must not disregard it. At the same time, they need to lead public opinion. Accordingly, the public interest for now is to flatten the curve of transmission of COVID-19. Yang Arif, even though at the time of the arrest, Mr. Hakim was only 21 years old and can be considered as a young offender, as defined under Prison Act 1995. However, courts usually do not consider age as a priority. In PP versus Yap Huat Heng, the learned judge were in opinion that the aim of punishment or the gravity of the offence should be given priority rather than the age. When Mr. Hakim violated the MCO, he has displayed the worst act of indiscipline. Yang Arif, by the age of 21, the accused by his nature should be able to understand the consequences of his act to disobey the MCO. So it is clear that the law enforcement officials does not at all acted in excess of their powers or have abused it, but he was arrested as part of policing. If only Mr. Hakim did not succumb to the regulated law, he would not be arrested for this offence, and he could also be staying at home safely with the family. It cannot be denied that defiance is least expected from the people, including the accused person, for whom the state wishes to do good at this critical time and period. Nang Arif, it is unfortunate to say that the prosecution also has a list of previous convictions and antecedents of Mr. Hakim. From the prison record, Mr. Hakim was once convicted with the offence of self-administration under Section 15 of the Dangerous Drugs Act 1952. In result of the conviction, he was sentenced with 1,200 ringgit fine and has undergone 2-year supervision. As Mr. Hakim previously has a bad record, the court should look into the case of PP versus Jafar bin Daud. In this case, the learned judge enhanced the sentence from 8 months imprisonment to 18 months for possession of 0.21 grams of heroin, as the accused had 5 previous convictions, 2 of which were possession of drugs. Nang Arif, when mentioned about Mr. Hakim's bad record, the prosecution are in doubt that the accused would repent to his offence if he is acquitted or sentenced lightly. Indeed, there are possibilities that the accused would reoffend to the regulation if not convicted and punished with the heaviest sentence. Therefore, before I end my submission, I would like to pray before the court to punish the accused with the maximum amount of fine of 1,000 ringgit or to imprisonment for a term of at least 3 months or more, not exceeding 6 months or both. That concludes the end of my submission. If I am not assist to the court, may I return to my seat, Arif? Much obliged.